I'm Paul Norrisongso. I'm the founder of Kinpath Surrogacy. I've been a lawyer since 1995 and we've had Kinpath since 2013. What I'd like to go over with you today are the 5 legal traps that you can fall into when you're doing international surrogacy. The first of our legal traps for international surrogacy is legal parentage and recognition. International surrogacy will always involve the principal conflict of laws. That means the law in our country A and the law in country B may be very different in defining who the parents are of a child born in that country. Kinpath has programs in Mexico, Colombia, and Ghana. In those countries, the child that is born through a surrogacy arrangement will ultimately be legally the child of the intended parents. Now you need to understand that in your home country, and let's use some real examples, the United Kingdom, France, the United States, Australia. The law in your country may say something very different about who the legal parents of the child are. For example, in France, the United Kingdom, and Australia, it doesn't matter what the birth certificate says, what your surrogacy agreement says, the legal parent of the child is firstly the surrogate mother, and if she has a husband, he is deemed to be the child's father. Therein lies the conflict of laws. In Mexico, Colombia, and Ghana, the intended father and the intended mother are the legal parents. They achieve that parentage by reason of the surrogacy agreement, perhaps a court order, and the birth certificate, which will contain only their names and not the surrogate mother's name. When you return home, you may need to go through another separate process, such as step-parent adoption, obtaining parenting orders, or a declaration of parentage from the relevant court in your home country. You will have a birth certificate that lists only your names, and that's merely the first step to obtaining citizenship and a passport of your home country, and then ultimately, on return home, any legal orders that you need. The second legal trap is sort of a subset of the first, and that is citizenship and passports. In our programs in Mexico, you will be entitled to citizenship for the child. That is Mexican citizenship for the child. In Colombia and Ghana, you will not be entitled to citizenship of those countries for the child. The exception in Colombia is if you were to follow a process where the surrogate mother's name goes on the birth certificate, even though it may be temporarily, then the child will be entitled to a Colombian passport. Later, once the surrogate mother's name is removed from the child's birth certificate, then its Colombian citizenship will also be relinquished. In Ghana, there is no Ghanaian citizenship granted to a child born through surrogacy. The laws with respect to citizenship of your home country are laws of your home country, and so they pay no particular regard to the law in Mexico, Colombia, or Ghana, or any other surrogacy destination in terms of defining who is the parent of a child. They pay no regard to the surrogacy agreement, the birth certificate, and any court order obtained in the surrogacy countries is only a factor and not a determinative factor relied upon in granting citizenship to your child from your home country. Your country may have rules and regulations that require you to provide a DNA test. Ultimately, the fact that needs to be proved is that this is your child. In some cases, that can still be proven even without a biological link, such as is the case in Canada and Australia. The next legal trap is that faced by single and LGBT parents. Mexico and Colombia are both LGBT friendly in that they allow same-sex marriage and allow same-sex parents to adopt children. Ghana is not so LGBT friendly. However, Ghana permits single parents to undertake surrogacy. In Mexico and Ghana, you can have a single father on the birth certificate with no mention of the surrogate mother. In Mexico, you can have 2 dads on the birth certificate. Likewise in Colombia, or 2 mums, and of course a heterosexual couple. In Colombia, since August of 2025, you can no longer put a single parent on a birth certificate. If a single parent is doing surrogacy in Colombia, then they will need to put the surrogate mother's name on the birth certificate for the first stage. You can then later go to court and have the surrogate mother's name removed. You need to bear in mind the laws relating to surrogacy and LGBT parents in your home country. For example, in Greece, there is an express law banning single parents, I should say single fathers, and gay couples from undertaking surrogacy. There are other countries, both Western and Eastern countries, where it will not be possible to present a birth certificate with two dads on it and obtain citizenship from that country. The next legal trap is contractual enforceability. In some countries around the world, surrogacy contracts are deemed completely unenforceable. They are considered against public policy or relate to prohibited conduct, and therefore the agreement is not enforceable. In our surrogacy destinations of Mexico, Colombia, and Ghana, the surrogacy agreements are enforceable, and the intention of the parties to give parentage to the intended parents is respected and honoured. In countries like Georgia, North Cyprus, and Greece, there are limitations on who can do surrogacy, and therefore there are issues with the enforceability of contracts. In North Cyprus, surrogacy is prohibited. There is no contract that is enforceable in North Cyprus, and you may end up with problems if everything does not go according to the plan being a constructed plan that relies upon you, the intended parents, pretending to be something that you're not. In Georgia, you must be a heterosexual couple, whether you're legally married or can prove your relationship of more than 12 months. As I mentioned earlier, in Greece, surrogacy is prohibited for same-sex couples or single men. The final legal trap is criminal exposure and genetic link to your child. In terms of criminal exposure, as I've mentioned, there are some countries that prohibit and provide significant penalties. Recently, Italy passed a law prohibiting surrogacy anywhere in the world by its citizens. It imposes fines of up to 1 million euros and imprisonment of up to 2 years if its citizen participates in surrogacy. Some Australian states also have prohibitions on surrogacy with an extraterritorial application. That means it doesn't matter where in the world its citizens undertake the program, it's a criminal offence. Genetic links. Although in our programs in Mexico, Colombia, and Ghana, you do not need a genetic link to undertake surrogacy, you need to ensure that your home country allows surrogacy with no genetic link. Canada and Australia do allow surrogacy, and we've had many clients from those destinations who have not had a genetic link to their child and have obtained citizenship and passport and travelled home safely. Most other countries require a genetic link. With this overview, I hope that we've managed to simply highlight some of the considerations you need to take into account when deciding on doing international surrogacy. Here at Kinpath, we like to ask questions about these issues so that we can make a recommendation to you on the best destination country for you, given your personal circumstances, to undertake. Thank you.